Hey everyone, it's Rob Ryder, and it's March 2nd, 2013, and some interesting things happened this week that are really the culmination of things that we put into place starting at the end of December, and waiting to see what would happen with them. And this week, a number of things have happened, and some are for the one little thing, and one is for the one big thing. So I don't know how long it's going to take me to tell the story. Um, so this maybe more than one video. But to understand what we'll be talking about, you should probably go to the talk shoe, which is Taking Clues from Ancient Books. There's the call ID. Listen to the January 7th and the 24th calls for the things to do with the one little thing, and the March 1st call for the things to do with the one big thing. And the March 1st call was one that I did with Roe that I sent out by email. It was too big to send by email, so I put it on TalkShoe. So if you didn't get it, there it is. March 1st call. Very interesting stuff. And you should also watch on YouTube on Rob Ryder, ROBBB, yes, 3Bs, Ryder. The videos Foreclosure Enjoyment Ordered by Court, Verdict Judgment Procedural Errors, Praecipe Act of a King. To be quite honest, really all the videos since the beginning of January have something to do with the things we're going to cover in this video. And that's my email address, courtofrecord@AOL.com. I'm going to have to apologize if you email me and I don't email you back, and if I missed your phone calls. I've been at this really, really hard the last 4 months. This is really all I do all day long from the time I get up, time I go to bed. And so I can see that things are changing, and I'm really pushing really hard. And so I've been kind of inattentive. In fact, I've been really inattentive. In fact, my mother let me know I had been inattentive because yesterday was her birthday. And when I called her to wish her a happy birthday, 83 years old, happy birthday, Mom, she reminded me she hadn't heard from me since Christmas. I chuckle now, right? But shame on me. That's pretty inattentive. And there's others I've been inattentive to also, and I apologize to everyone. But I've been really working hard at this, and I hope to show you some things that we can build on in the future to take it to the end. But let's just see what happened in the week that was, ending March 2nd, 2013. So we'll start with this. This is from Bob in Pennsylvania. And Bob was in the Court of Common Pleas in Pennsylvania for a foreclosure trial, not a hearing. 2.5 years of hearings, all that bullshit's over. Now it's a trial. And so what we did on the 14th is he put in an answer to the complaint, invoking equitable defense counterclaim by motion for summary judgment and just remedy based on preponderance of the evidence. And all that stuff is covered in the talk and other videos and so forth. And he put in a cover sheet, a verification filed, and certificate of service. And now we had the court date, and we'll actually look at these documents and talk about it more, but this is just what's on the computer now in his Delaware County, Pennsylvania. Verdict judgment. So, following a non-jury trial held in the above captioned case, I'm going to read this, I'll be reading it later anyways, but a verdict judgment was in an order upon consideration of plaintiff's motion for summary judgment motion. They denied the plaintiff, the bank's motion, for summary judgment. But they had found against Bob in the court case, right? So this is the interesting thing about that whole story, and we'll get to that in a second. So then what we did is we entered a praecipe. So on the 4th of February, Bob put a praecipe in. And ruled to file a complaint, because there's a rule in Pennsylvania that says, hey, if the petitioner hasn't filed a complaint, you put in a praecipe. Now, people understand the plaintiff has never put the complaint in, ever. It's the attorney. It's not the plaintiff. So it doesn't matter if it's verified or not. The plaintiff didn't put it in, so you can put in a praecipe for them to file their complaint. They haven't done it. They've brought a claim, but they haven't filed a complaint. So we did that, and then it has a cure time, and rule to file a complaint 20 days later, and then on the 26th, judgment of non-pros entered against the plaintiff for not filing a valid lawful complaint. Copy of the 10-day notice. Okay, so that was on the 28th, just a couple days ago, right? So here's the judgment index. There's the case number. Delaware County, Pennsylvania, case number. And you go down here. So I don't know. It says it's judgments, right? Like one's been entered. So what we can see is on the 26th, they put in a judgment for Bob, Faith M. Carr, against the bank and against the mortgage group. Judgment of non-pros. We're up here. Here's the ones where they put in at the court case, right? They put in for the bank and the mortgage group. Now we got them against them. Well, now what the hell do we do? Because over here, their judgments is where the res is, right? That's the property that's in dispute. And now what we're going to do is determine who the owner is. So let's see how this all went down. If we go back to this original order, first of all, this is the cover sheet that they send when they send your stuff, and you'll see it says Rule of Civil Procedure 236. Keep that in mind. We're going to use that to our advantage. But this was on the court date, and the judge had adjourned the case and said they would have his hearing or have his decision in a few days. But he didn't adjourn it and pick a day. And if you look at the definition of an adjournment, without a specific day being picked, it's sin die, right? Could never come back. So the court's adjourned, yet he comes out with a verdict. Well, he can't do that, right? You'd have to hold court again and have the verdict. He adjourned the case and didn't give anybody notice that the case was going again. And he did all this on purpose, right? Because then he gave a verdict judgment. Now look at this is a judge sitting on the Court of Common Pleas, right? This guy knows what he's doing. So, and now on this 24th day of January 2013, following the non-jury trial, held in the above captioned case, it was non-jury trial, where there was a verdict issued. And if you look at the definition of verdict, verdicts come from juries, right? And he made sure it was bold as could be, verdict. It is hereby ordered and decreed. Well, decrees come out of courts of chancery. They do decrees, and courts of law do judgments. And he said it was decreed. Yet he called it a judgment up here. And we can debate what that is. But by definition, a decree is from a court of chancery, a judgment is from a court of law. A verdict is from a jury. And this was a non-jury trial. Nevertheless, entered in favor of the plaintiffs, right, and against the defendant in the amount plus interest. This is where they found for the plaintiff. It is further ordered and decreed that an in rem judgment will and is hereby entered in accordance with the following or the foregoing verdict. You're going to see this really interesting what this in rem judgment may have done in this particular case. But so that was the judgment. And then another one of the sheets, and here was one of the orders. And this was in the case of Carr against the bank. Now, again, there's actually two cases going on. Bob had submitted his own complaint into equity, but he had the foreclosure going on, and they called him to the foreclosure. In fact, the secretary of the judge called him at home to remind him of this, having this hearing. And gets to the hearing, and that's when he points out that, hey, the plaintiff never signed the complaint, right? And in the courtroom, he pointed out that he had noticed the plaintiff that he was revoking the deed of trust because they hadn't signed the contract, and he had given him notice. And the judge says, oh, where's that at? And he's looking at it. There's a notice. There's a revocation. looks at them, they already have the Court of Common Pleas seal on them because Bob had gotten the things attested. And they put the Court of Common Pleas seal on something when you attest it. Here in Michigan, it's the Circuit Court seal. So, anyways, so now he puts out an order based on a judgment given during an adjournment, and the order is, upon consideration of the plaintiff's complaint, declaratory judgment, injunctive relief, as well as plaintiff's petition for equitable relief, yada yada yada, and talks about the non-jury trial again, ordered and decreed, hereby dismissed as moot. And really what that means, being dismissed as moot, means the question's already been asked in another matter and it hasn't been answered yet. So these things that were brought up still hadn't been answered. And the judges recognized that dismissed as moot. And that this case was discontinued and ended with prejudice. Now, it didn't say dismissed, or it just said discontinued. Didn't really know what that meant at the time, but I guess I really still don't, because we kind of went a little bit different way once we start looking at this. And this is the other order. Upon consideration of plaintiff, now this is for the plaintiff, their motion for summary judgment is denied, right? And so they denied the plaintiff's motion for summary judgment. They discontinued the case that Bob had brought in equity, because on the bench the judge says, these are really the same thing, aren't they? And Bob said, yeah, they pretty much are. And so the judge is getting rid of this case, which is the case they're not hearing now. This is actually the case that Bob had brought against them that hasn't been heard. He's putting an order in saying dismissed as moot. Question's already been asked and still hasn't been answered. What's the question? Who's the owner of the property? Still hasn't been answered. And he put an in rem judgment in against the property. Okay, so all that was going on with that. Oh, just real quick then, what's in rem mean? Legal term describing power of the court exercise over property. Okay, that's one thing. State courts have the power to determine legal ownership of the real and personal property within the state's boundaries. Okay, so this guy's putting an in rem judgment saying they have the power to determine the legal ownership of any or real personal property within its state's boundaries. Originally, in situations which property was identified but the owner was unknown. And I have to chuckle about was unknown because this is going to come up when we talk about what Roe found out at the county clerk's office. Unknown owners. Guess what? They have an index. And I find this very interesting. I didn't know this, right? Courts fell into practice styling their cases so, but as just ex parte, I didn't know an ex parte hearing was a property hearing, but ex parte is a property hearing. It's a hearing about the property. And then we're trying to claim the property. Right? We're saying the property is ours. And ex parte means you're going directly to the judge's chambers with your issue. And that's what bill of complaint is. So it's ex parte when it's a in rem jurisdiction. Means we need to be going to their office instead of into the courtroom. And that would have to do with it being a bill of complaint in chancery, which is addressed to the judges, not into the court, not as a court case. It's a complaint. So the use of this kind of jurisdiction in asset forfeiture cases is troublesome because it has been increasingly used in situations where the party in possession is known, the bank, which by historical common law standards would make him the presumptive owner, and yet the prosecution and the court presumes he is not the owner and proceeds accordingly. So in the case that the plaintiff brought, the bank, it was ruled, it was an in rem judgment, meaning that the court presumes he is not the owner of the property. It's been increasingly used in situations where the party in possession is known, right? Who's in possession? You're the owner, but you don't possess what they're talking about. The possession is the title to the property. That's in the possession of somebody else. It says you're the owner, but it's in their possession. All right, so if in law, if you have the title, you are the owner. That's what the law says, and that's why you need to have chancery, because chancery is the only place you can go and say, well, yeah, but they got it by fraud. Because the law doesn't care how you got it. If you walk in with a deed in your hand, you're the frickin' owner. All right, so court of chancery. Okay, and then quasi-in rem. What was interesting? A quasi-in rem action is commonly used where jurisdiction over the defendant is unattainable due to his or her absence from the state. We're absent owners. And we've, Roe found a heading for absent, unknown owners in her search this week. Great stuff. Where is it? Fair play and substantial justice. Yeah. Where was that one thing? Quasi-in rem. Sort of against the thing. Jurisdiction applies to personal suits against the defendant where the property is not the source of the conflict, but is sought as compensation by the plaintiff. The attorney of the court exercising the authority of the court exercising quasi-in rem jurisdiction is limited to a determination of the respondent's interest in the property. So if it's quasi-in rem, the authority of the court exercising quasi-in rem jurisdiction is limited to a determination of the respondent's interest in the property. Well, the respondent is the defendant, so they're talking about you. And their authority is limited to determination of your interest in the property. Do you have any interest in it? You want it or not? Yes or no, right? It's your property. Are you going to come get it? Yes or no? If not, we're going to let these people have it because they say they want it. Right? If you're not going to use it, they're going to. Funny how they make it work for themselves. Okay. There was one thing here that was, here we go. So there are two types of quasi-in rem jurisdiction. Plaintiff sues to secure pre-existing claim in the subject property. For example, actions that seek quiet title against others' claim to the property. Right? Quieting the title. How many people have interest in the property? Trying to get it down to where the only person that shows any interest is them, even though it's not theirs, they can claim it. Or the other one, the plaintiff has no pre-existing claim on the subject property. That is, the property rights of the owner are not in dispute, but rather the plaintiff seeks the property so that they may satisfy a separate claim. For example, a person who walks across, forgetting that, I don't need to read that part. This is what they're doing to you in a foreclosure. They're taking and they're opening a case in another jurisdiction, like through the county clerk's office or through the commissioner's court, wherever, because you can enter a lis pendens, you can enter a suit in any court you want to. And so they're going to get this judgment that you never answered. They're going to get a default judgment because they never, they're using the wrong addresses. You've never seen it. Now they have this claim, and they're going to go to this other court where, say, hey, he's over here, but I know where his property is, right? I wanted to pay this debt. To satisfy a separate claim. This claim's already been determined. And I was talking to Bob in Arizona. I think what they're doing, he brought this up that he had read, that if you have an abstracted title that's supposed to come to you, that's really what's supposed to come to you at the closing. You're supposed to get the abstracted title. But there could be some liens on it, right? That you would have to take off. And they really don't want to see these liens, because as long as the liens are on the abstract, whether you have it in possession or not, it's still against your property. So they don't want you to see the abstracted title. If you did, you'd take care of the liens. It would be free and clear. You don't need to worry about getting a land patent. You just have it. You would have the abstracted title going all the way back from the land patent to you, right? You would have the abstracted title. and it will have been certified that it's good from that date all the way back. So there's nothing they can ever come back and say, well, we have a prior claim. No, it's already been certified that this is the abstracted title. They don't want you to have that. So I think the underlying debt, when they talk about that in these mortgages, is that went to the bank, right? That's the title that transferred to the bank, and they paid the underlying debt, whatever the amount of the lien was. This lien could be $1 lien, could be a $5 lien, some crazy ass special assessment or general tax that you didn't know was due, didn't pay it, put a lien against your property, or against the land on the abstract. Could be old war debts. Who knows what it is? But everything's supposed to be forgiven every 70 years, right? So what is on there now? I don't know, but whatever's on there, once it's cleared off, there's no more liens or encumbrances against the property. And you have the deed says you're the owner. So I think they pay the lien off that's on the abstracted title. And if they pay the lien off, right, now the state or whoever has their money for whatever the liens were on there, then the liens come off and now they have it free and clear. And they've paid, $10 to clear something up. And that's the underlying debt upon which the deed of trust is supposed to have its authority, right? You're supposed to have paid back a loan of money. Well, where did they loan you any money? Well, the only place money would be used in this whole equation, I mean M-O-N-E-Y money, not Federal Reserve notes, is at the land level. And that's the level that we're at. So these are encumbrances against the land, and you take those off and there is no other encumbrances. Anything on the land is yours. Now you are the owner. You have the frickin' abstracted title. And I have to go look for it. I should have had it ready for this, but I was searching on abstracted title online, and somebody said bronze plaque of abstracted title. And sure enough, go look at it. It's on the outside of some building in Mount Pleasant. A bronze plaque of an abstracted title. I wonder what that's supposed to be telling us. I got off on a tangent there, but okay. So anyways, that's what this in rem. So the judge took jurisdiction over the property, but what hasn't happened is we haven't identified who the owner is yet. So that's what needs to happen. Now we need to be shown as the owner. We cleared up the bank. We cleared out the bank with the judgments by the Praiseby because they never put in a complaint, didn't file one. I guess they don't have one. Okay. So anyways, on the complaint, it talked about these being filed by Rule 236. And so when Bob was putting his case in, they said, oh, you're going to have to go get this and this off of this tree. And what was this Rule 236 stuff? And this is what it says. This isn't the same as it reads in the Pennsylvania Code, but this is the rule they're talking about for this court, special rule. This is their Rule 236. When filing any order, decree, or judgment, a party shall list on the documents the name and address of each attorney of record and each unrepresented party. Right? The name and address. Well, we can go back and look real quick. All right, here's a verdict. There's no addresses, right? No names or there's names, but there's no addresses. And it was filed by 236, and here's the order. It doesn't have any addresses either. All right, so all of these were by procedure incorrectly filed. And the judge did all this on purpose. He didn't follow Rule 236. Okay, so what was this here? What do we got here? Okay, now this is the Praiseby, right? So this is what Bob put in the very first Praiseby. Praiseby for judgment of non-pros. to the pro do notary. Enter judgment of non-pros against the above named plaintiffs. Pursuant to this rule, he's certified, so he's just quoting the rules now that are required to be for you to do to put in a praecipe. That was the second one I think he put in that got the judgment. Let's see here. Okay. Issue Rule PA RCP 1659. Mortgagee and real party of interest to file a signed, valid, lawful complaint by its corporate officers as plaintiff in the above case within 20 days after service of the rule, because that's what this rule is about. You put this in and say, hey, the real party of interest, you need to put in your complaint. You got 20 days. If not, I'm going to get a default judgment. Right? After service of rule, or the pro notary who holds the judicial records upon praecipe shall enter judgment of non-pros. So we sent it to them. They didn't answer. The civil side clerk of the Court of Common Pleas put a judgment of non-pros in the books. And this is just the notice stuff that went with it. I don't want to spend too much time on this. We'll never get done. Bonds praecipe. Okay, this is the first praecipe he put in. Where'd you go? All right. So there's the first praecipe going in. Asking for that. That's all this was, right? That piece of paper. And as you can see, it was sealed by the court. Beautiful. February 4th, 2013. Okay. And it was entry judgment. We already have that. Yep, already seen that one. This was the second praecipe. You know, I don't know where Bob found this writing to put on there. He did it on his own. Good deal. If you cannot afford to hire a lawyer, this office may be able to provide. I wonder if this is one of their forms. No. Okay, so that was the second one. Enter judgment because he had put the first one in, and now this is 20 some days later going in and putting the second one in on the 26th, and on the 28th they put a judgment into the judgment file, but it doesn't have any amount attached to it, so we got to figure out what to do with that. I want to show you on this. Oh, this is really good, right? This is Rule 237. Notice of praecipe for entry judgment, a non-pros or failure to file a complaint, or by default for failure to plead, right? Because you haven't pleaded in these particular cases, they're happening over in the commissioner's court. You don't even know they're going on. All right, they're getting default judgments against you and coming over to another court to have them enforced. So, that's why we need to find out where these are, and that's why what Roe is finding with the county clerk is so powerful. But, more on that later. But here, when a defendant appeals from a judgment entered in a magisterial district court, now this has to be like a police court, right? Your traffic tickets, whatever. Authorizes the appellant to file a praecipe for a rule as of course, upon the appellee to file a complaint or suffer entry of a judgment of non-pros. The entry of judgment of non-pros is governed by this other law and is subject to this rule. So this is what you do if you're going to traffic court, right? You take that thing and you put in a praecipe against the a rule as, of course, upon the appellee, right? So whoever brought the charge to file his complaint. You could do this in traffic court. Anything coming to the district court, whatever the hell that is. No judgment for non-pros for failure to file a complaint or by default for failure to plead shall be entered by the unless the praecipe for entry includes a certification that it was written notice of intention to file the praecipe was mailed and delivered. Right? So you got to put in this verification, or you won't get this judgment. And Bob put in a verification, swore it under oath. It's 10 days filing. Okay. Anyways, this stuff goes on and on and on. And it's just too hard to figure out how much I need to say at any one time, so keep going here. Mechanics liens. If a claimant has filed a claim and does not file a complaint, this is the same rule that Bob used, because it really looks like they're putting a mechanics lien against you. But it doesn't really matter, right? It has a couple of different rules that you can quote that tell you can put one of these in. Now, not every place has a praecipe, but all courts have rules, right? So you look in your court rules and see what it says people are supposed to do in those courts. And, look under complaint, look for verified complaint, look for what do you call it? I don't want to call it counterclaim. Maybe it is called counterclaim. How you put a counterclaim in on an ongoing suit. So, I can't tell you how to do it everywhere, right? I'm just saying, apparently there's some way you can do it in Pennsylvania. And unless you believe now that only Pennsylvania has this, oh my God, right? Well, we were able to get a judgment against a bank and a foreclosure after a trial, for God's sakes. By just putting in a praecipe. A couple of pieces of paper. Okay, so that's kind of Bob's deal. And then we had one with John. This one's crazy too. Let's see what happened. Okay, so John and Elaine are in New Hampshire, and on December 19th or so, about December 10th, they went in and they filed for a declaratory judgment for enjoyment of foreclosure because of the same reasons. They hadn't put in a complaint. A number of different reasons that were on their petition. And the judge said, well, I can't give you a declaratory judgment, but we'll give you a hearing and a temporary restraining order. So he put a stop to the sale, which was supposed to be on the 19th of December, which happened to be the same day that the court case was going to be heard. So we go to the 19th now, and nobody shows up for the bank. There's nobody there except Elaine and John and Gus, their friend. So the judge says he's going to put in an order and gave the bank a chance to reconsider. And a reconsider motion in Delaware, or not Delaware, New Hampshire is 10 days. 10 days reconsider. And in that time they did reconsider, they being the attorney for the plaintiff, and put in a special appearance. And from that, another order was generated saying there would be another hearing, which ended up being 2 days ago. So, all that being said, okay, so this is on December 21st. You are hereby notified that the court on the 20th has entered the following order: petition to enjoin foreclosure. The order made, a copy enclosed. Okay. So they put in an order to has entered the following order: petition to enjoin foreclosure. Okay, that went in. And then said final order on petitioner's request to enjoin foreclosure. On December 20th, hearing on the petition to enjoin foreclosure was calendared. The respondent, Bank of America, was served in hand on December 13th. The pro se petitioner appeared. Respondent Bank did not. Respondent Bank is enjoined from proceeding with foreclosure proceedings. This is a final order subject to reconsideration by the bank upon explaining why said respondent failed to appear and the assessment of a fine to cover the costs associated with the petitioner's appearance. So that was the order on that particular day. And then the bank did answer, gave whatever the reason was, improper service, whatever. And the proposed order that was proposed by them was to grant the motion. Motion is granted to subject to a payment. Motion is denied. And then another box. So hearing to be calendared to petitioner's request. Okay, so it's going to be calendared. And oh man, what did this one say? Yeah, same thing. Okay, so it's was going to be calendared, and then they just had a hearing here a couple days ago, Thursday, whatever last Thursday was, 28th. Well, at the hearing, it didn't go well for John and Elaine, because the outcome of it was an order that said that they're dismissing their petition for enjoyment of foreclosure without prejudice. So they were going to dismiss their motion to have for the hearing, to have it enjoined. And during the hearing, the judge said, "Well, do you have anything else for me?" And they really didn't have anything else to give them. You know, didn't really get to the précipe part with John and Elaine because they didn't have it the way that it was in Pennsylvania, and wanted to see what happened in Pennsylvania. But one of the things that John remembered was the judge kept asking the bank attorney that the foreclosure wouldn't, there would not be a foreclosure sale before July 6th, 2013. So they left, said, okay, well, shit, you know, they're going to have the sale now in July. We lost, right? Willing to try something else, but, you know, we lost. It's like, oh, okay, well, what are we going to do next? But it sounded like the judge was just looking for them to give them more. And if we had written rules, even in a motion, saying what the rule says has to happen, and if it doesn't happen, then this is the order that we want to have issued. It's really what we need to do, is we need to tell them what we want to happen based on their rules, just like doing a précipe. So if they don't call it a précipe, don't worry about it. Just say pursuant to whatever it is that says they have to do something, that it's been done. And the easiest one is just to mess with the complaint. Go find out everything you can about complaints in your state and find out what the plaintiff has to do to put in a complaint. Because apparently they're not putting in a complaint, they're putting in a claim. They put in a claim, but they haven't, the plaintiff still hasn't put a complaint in. So they put in a claim. Okay, so that happened on yeah, you know, that happened on Thursday. And then Friday night, John sends this to me. He got this letter. I got this letter. This is, you know, the very next day after the court case. Like, somebody must have been really going at it. So, clerk of the court. Okay, dear clerk, please find and close respondent's notice of corrective statement regarding the status of foreclosure sale for filing with the court. Thank you. What the hell's that all about? Okay. I wonder what this is. 206324. I always wonder when they write stuff on paper. You know, they're not doodling. All that shit means something. I have no idea what that means. Okay, but so they ended up putting this in to the court case, or sending it to the clerk at least, and then sending a copy to Elaine. Okay. Now, there's the docket number. The state of New Hampshire into the case. They're putting this: the respondent, Bank of America, by and through its attorneys, whoever they are, submits this notice of corrective statement regarding the status of the foreclosure sale in the above captioned matter. At the final hearing on the date, counsel for the respondent, bank, explicitly represented to the court and the petitioner on more than one occasion that the foreclosure sale at issue had been postponed till July 16th or July 6th. The information was proffered based on notations in a foreclosure file. Based on a notation in a foreclosure file, right? They said it had been postponed. After further discussing the matter with the foreclosure department, counsel learned that the notation relied upon was not the date to which the foreclosure had been postponed. Counsel further learned that the foreclosure sale had been canceled, not postponed. You're telling me the counsel for the bank didn't know that the foreclosure had been canceled? Yeah, okay. Thus, contrary to the counsel's representation at the hearing, no foreclosure sale can be held until there is a full compliance with this rule right here, RSA 479.25. And we're going to find out they probably didn't do this in the first place. The court relied on counsel's erroneous representation, in other words, their misrepresentation, relative to the postponement date of the foreclosure sale, in dismissing the petition without prejudice. Specifically, this court advised the petitioner that the dismissal was subject to her right to, the court relied on counsel's erroneous representation relative to the postponement date of the foreclosure sale in dismissing the petition without prejudice. In other words, they took what the attorney said for the reason for dismissing the petition. Okay? That's cool. I wonder what else I had to say. Let's see here. Refile a petition prior to July 6th, the postponement date for the respondent. The making of the representation regarding the postponement of foreclosure sale, counsel did not intend to mislead the court or petitioner. Counsel apologizes for inconvenience such of his erroneous statements at the hearings. In light of the foregoing, counsel believes it necessary to seek the amendment of the order issued by the court. Accordingly, counsel hereby notifies the court and the petitioner that upon receipt of the court order, he will be filing the appropriate motion along with proposed order to account for the erroneous statement detailed above. Well, if they dismissed the petition, the only amendment there can be to the order that dismissed the petition is to reinstate the petition. I guess. So can't wait till next week and see what comes of this. Yeah, this just happened on Friday night. Got this last night. It's like, well, what in the hell is going on here? They fine for the bank in the courtroom, and next thing you know, the bank is putting in a you caught us with our pants down letter. Now, understand that John and Elaine don't know anything about this, right? This wasn't their doing. This came out of the blue for some reason. Somebody must have talked to somebody who said, brother, you better go back and look at what you said. because they're admitting to false representation of the facts. Counsel apologizes for any inconvenience caused by his erroneous statement at the hearing. And the judge kept asking him about this, this date that the sale was going to be on, July 6th. Won't be before the July 6th, will it? No. Yeah, whatever the conversation was. And now they're going to amend the court order. And all that was ordered was for the dismissal of the petition. Well, if they don't dismiss your petition, do they grant your petition to have enjoyment of the foreclosure based on the preponderance of the evidence and give me back my property? More to come. Okay, I'm going to shut this one off now, and I'll do another one separately on the stuff I had from Roe and a couple other things. So